Good evening, Ms. Chavez.
Good evening, Your Honor. How you doing?
I'm good. All right, we'll take we're going to take the Cobb County, then ACDC, and then we'll take your case, okay?
Okay, perfect.
Okay, just let me get this thing set up here. I don't know if we have I'm on position 16. The first one that's called out is Anthony Cantu DeVille. And it says Ms. Markowitz said at first it was a conflict. Do we have anybody here from conflict?
I'm not sure, but Miss Rendon, she should be joining the Zoom because she has another case on here.
Okay. All right, we'll hold on to that one then. How about Ronrico Sims? Wave your hand if you're here. Best you can. Thank you, sir.
And Judge Mary Agramonte, I'm here on his behalf. I work with Scott Smith's law firm, and we're ready to proceed.
Okay. All right. This position, Bostic, you here? Bostic. Yep, Bostic. And Miss Jones, Miss Chanel, Miss Young.
Yes, Your Honor, I'm here.
All right. I got Bostic. All right. It's position 8. Ronrico Sims, 22 CP 213214, 102 days without indictment. There is no bond as of October the 5th for possession of marijuana with intent to distribute and unlawful for a person employed by, associated with a criminal street gang, or to conduct or participate in criminal street gang activity. Rob.
In regards to Mr. Sims, multi-state offender, 2 in California, 2 in Texas, 1 in Alabama, 27 in Georgia. Open case 22 CP 211198, trafficking in coke, VGCSA schedule 1 or 2 with the intent to distribute. Open case in another county for street gang activity. Multiple convictions. 09 theft by receiving stolen property, felony escape, offense, unlawful transportation of a firearm, misdemeanor, battery, family violence. In 2020 has a hold in Anniston, Alabama for an FTA. The hold was from July of 2022. Couple of misdemeanor convictions, nothing further.
All right. Ms. Agramonte, just so you know, there's I don't know how good it is, but on Odyssey, there's a warrant that's listed, it says foreign warrant. It's a 13C 56415. I don't know where it's from, but it's on Odyssey just in case. Go ahead with your bond argument.
Sure. Thank you, Judge. As you already mentioned, he has been in custody over the 90-day mark. And so we are asking for a reasonable bond in this case. A little bit about Mr. Sims. He has significant ties to this community. He is born and raised in the Atlanta area, in the downtown Atlanta area. He has 3 children, one of which just graduated from Georgia State University. He has a very close relationship with each of his children. He is gainfully employed. He works as a promoter in the entertainment business, and even went back to get a diploma back in 2018 to further his education, and does have a diploma for that. I do see online that there is a warrant showing out of Alabama, which is not accurate. I did confirm that with Alabama today, and I try to put the court and the sheriff's office in communication today to try to get that alleviated, but it's still showing online. But that kind of goes towards this case in general. Just very briefly, the possession of marijuana came to be. He was at a gas station in Atlanta when a police officer approached him. They asked him for his driver's license. There was no traffic infraction or anything. It was just a voluntary encounter. Let me see your ID. And knowing he didn't have any issues there, he, completely complied, handed over his ID, and he was arrested for this out-of-state warrant in Alabama. And then a search incident to arrest showed 2.8 ounces of marijuana in his vehicle. There were no guns, no firearms, no evidence of gang furthering any sort of gang activity in this case whatsoever. And I'm nearly certain, if not absolutely certain, that the gang charge is not going to stick in this case. After that arrest, knowing that that warrant was not accurate, his family worked with the court in Alabama to fix that warrant situation. I am prepared to share my screen, Your Honor, if you'd like to see the warrant recall on that. It was issued 4 days after his arrest, once they realized, oh, wait, he did go to court this past month. The warrant was not accurate. So, Your Honor, do you want to see the warrant recall?
That's okay. The DeKalb, the warrant that's out here on Odyssey is out of DeKalb County.
Really? So the one that I saw on the system that I have access to, which is the Fulton inmate search, showed Alabama, and it showed the warrant numbers for the case that he's fighting. So I'm not familiar with a DeKalb, and I did not see that on my end. But I'd be happy to obviously work with him on that to make sure that that is handled. I'm not aware of any open cases other than the one in Fulton that was mentioned. I think the pretrial services had mentioned in out-of-state or maybe in-state gang charge, and I'm not familiar with that. And I'd be happy to work with DeKalb to fix that issue, because what I'm seeing is an AL foreign county on the Fulton inmate search. So, but I say all that to say he's truly not a danger to this community. This is a case where he had a little over 2 ounces or 2.8 ounces of marijuana with absolutely no guns. He was absolutely cooperative with the police officer. And so we are asking for a reasonable bond, and a reasonable bond is going to be different for everyone. It's the amount that's going to keep them to come to court, to secure their attendance in court. Mr. Sims is of limited means. His family is of limited means. He did not grow up a wealthy person. And so we are asking for a $15,000 bond in this case. That is a lot of money for him and his family, and it would absolutely secure his attendance in court. He's never failed to appear in court, to my knowledge, and does go to court when asked. And even most recently, this Alabama case was a driving with a suspended license. And he was able to reset that court date, go through the motions of getting his license back, and then went back to Alabama. And that just goes to show that he's not dismissing these court dates. Even something like a suspended license is something he's going to make sure is correct before he goes back to court. And so I would ask for a $15,000 bond in this case.
Yeah, what says the state?
Good afternoon, Your Honor. Mr. Sims, when you look at his criminal record, he has 27 cycles just in Georgia alone, with convictions in armed robbery, hijacking, and drugs, Your Honor. When the investigator did their search on him, we found cases in Texas and California. California case was a drug case, and the Texas case, I think, was an armed robbery. He has an extensive history dating back to 1998, Your Honor. He's a documented member of the Atlanta Blood Gang. When the officers actually looking for him this night, they actually were on the scene doing a dropping by. They observed these individuals in the parking lot, hanging out. They did encounter Mr. Sims, who was standing by his vehicle. They asked Mr. Sims who vehicle was. He acknowledged it was his. They smelled the marijuana. He gave them a small amount of marijuana out of his pocket. And at that time, they were going to just arrest him and charge him with the possession of marijuana less than an ounce. When the dogs actually walked around the car, that's when they found the additional marijuana. Initially, they could not get in the car because Mr. Sims had actually, I guess he observed them. He gave the keys to the clerk, so he wouldn't have the keys to the vehicle, to the car. Eventually, he came forward and told him that the keys were in the front at the clerk's office in the store. They went, got the keys, and that's when they were able to actually search the vehicle. Your Honor, based on his history, he clearly poses a threat to the community. His multi-state offending shows that he's a flight risk, Your Honor. Based on those, we asked the court to set a reasonable bond. We asked that bond be above at least $100,000 on the gang charge, and on the marijuana charge, at least $20,000.
All right. 3 North, booth 3. Stop what you're doing. Stop holding your hand up, showing your knuckles, whatever your tattoos. Stop. All right. No drugs unless prescribed, no alcohol, no weapons. You can have an ankle monitor paid for by the Orca Project with a 24-hour curfew, court, lawyer, and medical. No further contact with anybody associated with, pledging, running with, whatever, for the Atlanta Blood Gangs, ABG, SMM, Sex, Money, Murder, the Inglewood Family Gangster Bloods. Also, no replicas of weapons. What address is he going to be living at, Ms. Argamonte? Oh, you're on mute.
Your Honor, I had that written down, and it's not on my most recent piece of paper in front of me. And so can I email your case manager in 30 seconds?
Is it in Fulton County?
It is in Fulton County.
Okay. All right. Now you need to file a change of address into the case. So I'll do let's see, 10,000 on count one, 75,000 on count two. Best of luck to you, sir. You can leave the booth. Thank you, Ms. Argamonte.
Thank you, Judge. Have a good evening.
You too. Let's see, Brianna Coleman. We have Miss Rondon here yet?
I don't see her here present. I'm going to email her, Judge.
Okay, sorry, Miss Coleman. Let me get there it Rondon. Okay, well, let's take ma'am, if you can go sit, I guess you can hang out. We're gonna try to find your lawyer, Miss Rondon, okay? Ms. Chavez, raise your right hand, Ms. Chavez. You swear or affirm you'll translate from English to Spanish, Spanish to English, and best your knowledge, skills, and abilities.
I do, Your Honor.
All right, everybody, don't forget about the translator, the interpreter. So don't go too fast for her and don't keep talking. So give it to her in little bites. This is position 3, Bostic. Jose Perez, 22 CP 208823.
Este es el caso de José Pérez, 22 CP 208823.
Been in 265 days without indictment.
268 días sin haber sido acusado formalmente.
There's a $400,000 good bond on trafficking in methamphetamines.
Y tiene una fianza de 400,000 por tráfico de metanfetaminas.
This was of August the 8th.
Esto sucedió el 8 de agosto.
All right, Ms. Chavez, want to hear that soccer announcement voice? Ready? Free trial.
Antecedentes penales.
Nice. Fantastic. Go ahead, Bostic.
In regards to Mr. Perez, 4 prior arrests, 1 misdemeanor conviction for theft by shoplifting, 1 FTA in 2018, nothing further.
Para el señor Pérez hay 4 arrestos previos, un delito menor y a falta de comparecer a una audiencia en el 2018 ya no hay más.
All right. Go ahead, Mr. Sperling.
Señor
Thank you,
Sperling.
Judge. Good afternoon, Judge.
Buenas
Judge.
tardes, su señoría.
My client is 43 years old.
Mi cliente
Go
tiene
ahead.
43 años.
He is a lawful permanent resident of the U.S. since 1990, Judge.
Desde 1990 mi cliente ha sido un residente legal.
He is originally from Dominican Republic,
Originalmente es de la República Dominicana.
has a Georgia driver's license.
Tiene una licencia de conducir en Georgia.
He was gainfully employed working in construction.
Él trabajaba con su salario en construcción.
As the court has heard from pretrial services, he has 1 misdemeanor conviction in 32 years of living in the U.S. legally.
Como su señoría ha escuchado de los servicios de pretrial, él solo ha tenido una condena por un delito menor en sus 32 años en los Estados Unidos.
Judge, I certainly acknowledge that the charges are very serious.
Yo reconozco que los cargos en contra de él son bastante serios.
There is no downplaying that.
No se puede negar eso.
Based on my client's description of the facts to me, which I am certainly not going to disclose today,
Basado en la descripción de los hechos que mi cliente me ha dado y que claramente no lo voy a dejar saber hoy,
the case would appear to me to be defendable.
me parece a mí que este caso se puede defender.
Judge, my client was arrested on May the 4th of 2022.
Mi cliente fue arrestado el 4 de mayo de 2022.
I was hired May the 5th of 2022, a day
Me-
after.
Un día después, el 5 de mayo, me contrataron a mí.
I have been requesting a preliminary hearing now for about 9 months.
Por 9 meses ya he estado pidiendo una audiencia preliminar.
On multiple occasions,
Muchas veces
we came before Your Honor, Judge, on August the 8th of 2022, at which
Sí.
time Your Honor granted a bond reduction to $400,000, which is what the bond is currently.
vinimos ante usted, su señoría, el 8 de agosto del 2022 para solicitar una reducción de fianza, lo cual usted redujo a $400,000.
At that point, my client had only been in custody for 90 days.
En ese momento, mi cliente solo había estado bajo custodia por 90 días.
At this point, Judge, 8 months later, my client remains unindicted. He doesn't know the basis for the charges. And for some reason, the state has not indicted the matter.
Y ahora estamos 8 meses después que mi cliente todavía no tiene cargos formales, no sabe cuáles son los bases de los cargos y tampoco el gobierno le ha dado los cargos formales.
There is no way that my client will ever post a bond in the amount of $400,000, $300,000, $200,000.
No hay manera que mi cliente pueda pagar una fianza de 400,000, 300,000, 200,000.
Judge, my client has a very good criminal record,
Mi cliente tiene buenos antecedentes penales.
has his entire family in the Atlanta area.
Igualmente su familia en el área de Atlanta.
I would respectfully submit that he is a good candidate for bond judge, despite the seriousness of the offenses for which he is presumed innocent, of course.
Yo respetuosamente lo considero que le menciono a su señoría de que él es un buen candidato para una fianza, no obstante los cargos que son bastante serios.
I would respectfully ask for a good bond in the amount of $100,000
Respetuosamente su señoría, yo le pido que le dé una buena fianza de $100,000.
with whatever conditions, including an ankle monitor and any other conditions that the court finds appropriate.
Con cualquier condición, ya sea un grillete en el tobillo o cualquier otra condición que la juez considere apropiado.
To include reporting to pretrial services, of course, if need be.
Y incluyendo que se reporte a servicios de pretrial si eso fuese necesario.
Respectfully, Judge, I think that $100,000 bond is high enough.
Respetuosamente, su señoría, yo le pido que le digo que $100,000 es bastante alta ya,
Where it will assure my client's presence,
lo cual
especially since he will have to go through a bonding company to be able to secure his release.
con eso se aseguraría la presencia, especialmente que esto lo va a tener que hacer a través de una casa de fianzas.
Knowing that that always adds an additional layer of safety that the defendant will appear in court, since he'll be reporting to both them and pretrial.
Porque eso le pone una capa más para asegurarse de que él se va a estar reportando, porque tiene que reportarse a pretrials y también a la casa de fianza.
Respectfully, Judge, I would ask for a $100,000 bond in these circumstances, especially understanding that the case has been unindicted since May.
Su señoría, respetuosamente, le pido una fianza de $100,000, especialmente bajo las circunstancias ya que este caso no ha sido acusado formalmente desde mayo.
And Judge, last but not least, perhaps it would be different if there had been a finding of probable cause at a preliminary hearing, which of course, unfortunately, has not happened as of yet.
Y lo último, su señoría, yo creo que eso sería diferente si ya hubiera habido una audiencia para causa probable, una audiencia preliminar, la cual no ha sucedido todavía.
That would be our presentation, Your Honor.
Esa es nuestra presentación, su señoría.
I had before, he wasn't going to be living in Fulton County. Do you have an address where he'll be living?
Como anteriormente él iba a vivir en el condado de Fulton, ¿usted tiene la dirección donde él va a estar viviendo?
Judge, he lost his apartment, of course, as a result of the period of incarceration. If the court was to grant bond, if I could go into a private room briefly and get a new address from him, because I frankly don't know where he would be living. He's got a lot of family here. He's got friends, family, 30 years worth of contacts. But as far as a solid address, I would have to go into a private room and get that address from my client.
Su señoría, él perdió su apartamento, pues ya que ha estado encarcelado. Si usted me lo permite, yo pudiera obtener la nueva dirección, porque no la hace en este momento. Si usted me pasa a un cuarto privado, la puedo conseguir. Creo que se puede, porque él ya que tiene familias y parientes y amigos aquí, porque ha vivido aquí por 30 años.
So he'll be able to live outside of Fulton County like he would before, correct?
Your Honor, the interpreter requests a repetition.
he'll be able to live outside of Fulton County, correct?
Pero él va a poder vivir afuera del condado de Fulton como anteriormente.
Judge, he was residing in Marietta prior to the date of his arrest.
Antes del arresto él estaba viviendo en Marietta.
So it's not like he's going to be moving to Macon, but I would respectfully submit he would be living within the Atlanta metropolitan area for sure.
Okay.
Sonaba que iba a vivir en Macon, pero yo le aseguraría que él va a vivir en el área metropolitana de Atlanta.
What says the state?
¿Qué dice la fiscalía?
Good afternoon, Your Honor.
Buenas tardes, su señoría.
The state's position is that the bond as currently set is fair and reasonable.
La posición de la fiscalía es que la fianza que tiene en este momento es razonable.
The facts alleged in this case include a traffic stop of the defendant that produced over 15 kilograms of methamphetamine that was stored in 3 separate car batteries.
Los hechos de este caso alegan de que se hizo una parada de tránsito en el cual encontraron 15 kilogramos de metanfetamina que lo encontraron en 3 espacios diferentes.
Although this defendant does not have a felony criminal history, we do believe that the bond is fair and reasonable considering the facts in this case.
Aunque él no tiene ningún historial de delitos mayores, consideramos que la fianza es justa y razonable en este caso.
Judge, we have made almost weekly requests for a preliminary hearing.
Gotcha.
Because-
We'll put it on our list. Sometimes, this is a big task we're taking on here. So I'm sure if you want to email at orca at fultoncountyga.gov, kind of give them a heads up because that's why we're doing night court, trying to catch up, and we're doing extra prelims. So we'll get you on there. I mean, some of them fall through the cracks. So just email Orca with a case number, maybe a copy of the motion that you filed, and we'll get it on there. Okay.
Su señoría, yo he estado haciendo llamadas semanalmente para que me den una audiencia de preliminar. La juez dice, sí, lo que usted puede hacer es mandar un email. Por eso nos encontramos ahora con este programa de Orca para podernos poner al día. Yo creo que esta se perdió en el papeleo.
Judge, with all due respect, we've made over 10 requests. So at this point, I would just ask for a $100,000 bond, Judge.
Gotcha.
Con respeto, su señoría, quiero dejarle saber que yo lo he solicitado más de 10 veces y por eso respetuosamente le pido una fianza de $100,000.
No drugs unless prescribed, no alcohol, no weapons.
No puede utilizar drogas, solo si se le es prescrita, no alcohol, no armas.
Going to have an ankle monitor paid for by the Orca Project with a 24-hour curfew.
Va a tener un grillete pagado por el programa de Orca y
Court, lawyer, and medical appointments.
Con arresto domiciliado de 24 horas, solo puede ir al tribunal y a citas de médico.
You can leave for employment. You have to provide proof of employment.
Si quiere salir para trabajar, tiene que dar prueba de que está trabajando.
Of course, name of the employer.
El nombre del patrono.
Schedule and the exact location you'll be working.
El horario exactamente, el lugar donde va a estar trabajando.
You have to do that on a weekly basis if that's your scheduling.
Y si es cuestión de horarios, cambia, tiene que hacerlo de manera semanal.
You have to notify the ankle monitoring company and your lawyer, who will then tell the state.
Usted tiene que notificar a la oficina que le está monitoreando el grillete y a su abogado para que él le notifique al estado.
Stay out of Fulton County unless you're here for court or to see your lawyer.
Usted tiene que mantenerse afuera del condado de Fulton solo si viene a ver a su abogado o a una audiencia.
Don't stop and get gas in Fulton County. Don't stop and get lunch. Go straight to the courthouse, get in your car and leave. Fill up the gas before you come here.
Cuando usted viene a las audiencias, no pare a que le pongan gas o a comer en Fulton. Simplemente cuando viene a Fulton es ir a la audiencia y salir inmediatamente.
I'll do $200,000 good bond. Best of luck to you, sir. You can leave the booth.
Una fianza de $200,000. Buena suerte, señor. Ya puede irse de su cuarto.
Thank you so much, Judge. Is there a way, Your Honor, that I can have a very brief conversation with my client?
I don't really know. See all these people on here?
It's okay. No big deal.
Okay.
One quick question, Judge, because I am not familiar with the ORCA program Is that through pretrial services?
Orca is the killer whale. There's no really acronym to it. It's just the handling all the backlog cases.
Okay, I understand.
Su señoría, quería preguntarle que si yo puedo tener una conversación privada con mi cliente. No puedo porque es mucha gente. Su señoría, usted me puede decir si Orca se trata, lo hago a través de Pretrial Services, y le dice no, es un programa que está manejando los casos atrasados.
Okay, Madam Interpreter, if you could please tell my client that I will go and visit with him in the next couple of days so that we can discuss the matter.
Señor, su abogado está diciendo de que él va a venir a visitarlo en los próximos 2 días para que puedan tratar el caso entre ustedes.
And please tell him that his bond was reduced to $200,000.
Y por favor, sepa de que su fianza fue reducida a $200,000.
I mean, she interpreted what I said. He should have heard that.
Thank you, Your Honor.
All right. Have a good evening.
Have a good evening. Take
All
care.
right. Ms. Rondon, I see you're here now. Ms. Rondon, are you handling Anthony Cantu DeVille also?
I do not believe so. I think
Ms. Markowitz said that was a conflict case.
I believe he needs to be assigned a C3 attorney.
Okay.
I'll double check on our system for an update on that.
All right. So we'll go ahead with Ms. Coleman. That's you, right, Ms. Coleman? Wave your hand. Thank you. All right. Position 17, Ms. Rondon, 22CP207002. Brianna Coleman, 332 days without indictment, aggravated assault with intent to murder, ×2, aggravated assault with a deadly weapon, willful obstruction of a law enforcement officer by use of threats of violence, felony. There's a $110,000 good bond. Trial as of July 25th.
Prior arrests in Georgia, 2 in Virginia. Open case 21CR004967C. Simple battery, 2 counts. Does not appear to have any convictions. Nothing further.
All right. Go ahead, Ms. Rondon.
Before you is Ms. Coleman. She is 24 years old. As pretrial stated, she has no convictions, and I didn't hear any failures to appear. There are some underlying mental health issues, and my office is going to be working to address those. Her mother, Michelle, is very involved in her life, and she does have a good support system surrounding her, to include her mother's entire family. We would be asking for a reduction in the current bond amount that is set at $110,000. That amount is tantamount to no bond, as Ms. Coleman is indigent. Thank you.
What says the state?
Good evening, Your Honor. ADA Dixon for the state, Your Honor. Although the defendant does not have any criminal history, Your Honor, we've heard no change in circumstances to warrant a bond reduction, Your Honor. If I could go into the facts, as this is a serious violent offense. The defendant walked into a Greyhound station, Your Honor, and stabbed one victim in the back. It was an unprovoked attack, stabbed her with a pocket knife. And then as another victim, Mr. Taggart, was trying to push the defendant away. He was then stabbed twice, Your Honor, resulting in injuries to the chest and the shoulder. And then once police officers arrived, the defendant still had the knife in her hand and advanced toward Officer Boyd as he commanded her to put the knife down. Your Honor, the state believes that given the fact that this is a serious violent offense, the bond that's already preset at $110,000, Your Honor, is an appropriate bond.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 232 Forsyth Street in Atlanta. Stay out of Fulton County except for court and to see your lawyer. You can have an ankle monitor paid for by the county with a 24-hour curfew except for court, lawyer, medical appointments. And you also can leave for MH treatment if you like to. And if you have to get a job, you can leave for employment as long as you provide the name of your employer, proof of employment, the schedule, and the exact location you'll be working. You have to provide the jail with an updated address upon release. That ankle monitor will be paid for by the Orca Project. I got $25,000, $25,000, $25,000, and $15,000. No further contact with Liam Taggart, Taggart. No further contact with Anna, last name Borukhov, and Officer Omar Boyd of Atlanta Police Department, unless it's in his official capacities. Best of luck to you, ma'am. I got Michaela White. This is 15, Bostic, 22 CP 211260, Michaela White, 172 days without indictment, cruelty to children in the second, cruelty to children in the first, cruelty to children in the second, reckless conduct, no bond as of August the 6th. Free trial. What?
Oh. No prior arrest.
All right. Go ahead, Ms. Rondon.
Before you is Miss White. She is 26 years old. As pretrial just stated, no prior arrests. So she has no convictions, no violent history, no failures to appear. She is 26 years old. I already said that. She has a good family support system. Her aunt Charlotte is very involved in her life and has offered to allow Miss White to move home with her in Texas. I can provide that address to the court. Miss Williams works from home, so she would be able to be home and provide the proper support. So Miss White, the children in this case live with different family in the state of Virginia. So Miss White would not have contact with the children. There are also some underlying mental health issues that my office is working to help address. We would be asking for a reasonable bond to be set in this case. Not to exceed $50,000.
So Ms. Rondon, is there a defects case open that she's going to have to be working?
Not that I'm aware of.
Okay. I mean, I could put a bond condition in there that if there's a defects program she's supposed to be working, that obviously she can have contact to follow the defects plan.
That would be great.
All right. What says the state?
Your Honor, this defendant does not have a criminal history. However, the twins in this case were less than 2 months old at the time that they were taken into the hospital, one of which had a broken rib. So they did have pretty serious injuries. So we do believe that the defendant should stay in no bond status, considering the moving about that she may do, also considering the risk to the victims if she does have contact with those victims at all. However, we do understand that this case has been unindicted for quite some time. As such, we would ask that a bond, if it's set, be high for each count of cruelty to children. We would ask that the bond be $50,000. The reckless conduct, really a UJR for that one.
All right. No drugs unless prescribed, no alcohol, no weapons. No further contact with the two minors. Initials KK and initial KK. So there's two of them. They're both minor children. Stay away from 1356 Epworth Street Southwest. No further contact with Kenneth King. That's your co-defendant. Have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical. You'll be able to have contact with the children if you are following a DFACS plan only. And you have to submit the DFACS plan to your attorney. They'll present it to the state. You have to let the ankle monitoring company know too, ma'am. So if there's not a DFACS plan, then you don't get to see them. No contact whatsoever. And provide an address where you'll be living upon bonding out. Not a mailing address, an address where you will be living. Stay at a Fulton County this year for court or to see your lawyer. You okay with her going to Texas, Ms. Valentine?
Your Honor, if that's where she would have the best treatment or care, the state is not opposed to that as long as she does appear for any court proceedings that she's required to attend.
All right. Also, ma'am, stay at the state of Georgia unless you're here for court or to see your lawyer. You can fly into the airport or drive, but then go straight to court and get out of Georgia after that. I'm going to do $45,000 on each count of cruelty and UJR through the jail on the reckless conduct. Best of luck to you, ma'am. All right, Jerry Holland. Thank you, South Annex. Jerry Holland. I think he's ACDC. Are they not here yet?
I see Mr. Holland. He is waving.
Okay, got you now. Got you right there. Okay. All right. Jerry Holland. It's 20, Bostic. Jerry Holland. CP 211248, 172 days without indictment, no bond as of August the 6th, and aggravated assault with an object, pre-trial.
In regards to Mr. Holland, extensive arrest history, at least 51 prior arrests, at least 12 felony convictions, 2 arrests for probation violation, currently on probation for burglary, sentence in 08. Extent was a long sentence, 10 years confinement, 30 years probation out of Newton. Convictions are numerous convictions for controlled substance, theft by receiving stolen property, and forgeries. Nothing further.
All right, Ms. Rondon, I've got these gonna live at a Jonesboro, Georgia address.
He did have housing at the Welcome House, a government program here in the city, and we are hoping that he'll be able to return there.
I don't know if they'll allow him to return there since this incident happened there, allegedly.
I can double check that Jonesboro
Yeah.
address.
Sir, are you gonna go back to a Jonesboro address? Give me a thumbs up or a thumbs down. Do you know where you're gonna live? Thumbs up or thumbs down? Or sideways. All right, go ahead, Ms. Rondon.
Before he was Mr. Holland, he is 64 years old. He's been in the Atlanta area since 2018, and his whole family on both sides live in the state of Georgia. He does have a great community support system surrounding him. He has been in custody for over 90 days, and so by law he is entitled to a bond, and we would ask bond to be set in this case not to exceed $20,000.
What says the state?
Your Honor, the state would ask for a bond in the amount of $200,000. As you heard from pretrial, he has an extensive criminal history. Your Honor, I counted 16 felony convictions, which makes him a state C recidivist 4 times over, Your Honor. Going into the facts of this case, Your Honor, the defendant allegedly stabbed the victim, Mr. Willie Smith, twice. It appeared to be over some money, Your Honor. The victim did sustain injuries in which he went to the hospital. Your Honor, I also show that the defendant has 1 failure to appear, so we do have concerns that not only is he a risk to commit further felonies, but he is a risk to flee, Your Honor, and not show back up to court. So that's why we're asking for the bond in that amount, Your Honor.
All right, no drugs unless prescribed, no alcohol, no weapons. You have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, and medical. Stay away from 234 Memorial Drive Southwest. That's the Welcome House. No further contact with Willie Smith. Sir, you have to provide an address to the jail to get bonded out. If you don't provide an address where you'll be living to the jail, they're not going to let you out. That's one of the conditions. And also, Ms. Rondon, I saw something on there that made me some Newton County warrants outstanding.
Yes, I'm aware of those.
Okay. That ankle monitor be kept paid for by the Orca Project. $100,000 good bond. Best of luck to you, sir. And Ms. Rondon, I'll go to the next one if you want to check to see if Cantu DeVille is a C3.
Yes, I will right now.
All right. All right, Mr. Scheib, we got position 1, Demetrius Denard Johnson, 22 CP 209122. 243 days without indictment. Let's see, a $5,000 split bond as of May the 17th, entering auto and criminal trespass. Pre-trial.
He's also number 2.
What? Hold on, yep, 2 cases. My bad. Good for you. You're on the, let's see, I got Demetrius Denard Johnson, 22 CP 209123, 243 days without indictment, entering auto, criminal trespass, loitering and prowling. Pre-trial.
4 total arrests, open case, 22 CP 209378, entering auto, 7 counts, criminal trespass, 22 CP 209380, theft by receiving stolen property, on probation, marijuana with the intent to distribute, 61322, 2 years confinement, 20 SC 174591, nothing further.
All right, Ms. Shaw, we only had one that needed an interpreter, right, Ms. Robinson?
Yes, Judge, that's correct.
All right, thank you, Ms. Chavez. Have a good evening. All right, go ahead, Mr. Scheib.
Judge, just to make sure, I've got this printed out. We're trying to get a bond on criminal trespass and the last four numbers 9123, and then also loitering and prowling. So we're asking for a total bond of $6,000, $3,000 on each. And what we're trying to do is get a bond also on theft by receiving, and that CP number is 9122. That's theft by receiving, felony, and criminal trespass. I'm asking for a $7,000 total bond on that, $3,500 on each one.
All right, so in 2-2, it's entering auto and criminal trespass. And ending in 2-3, it's entering auto, criminal trespass, loitering, and prowling.
Correct.
There was no theft by receiving. It was just. Bostic, did pre-trial come off of these yet?
Come off of what?
Did they come off of this bond? Because it's split and one goes through pre-trial.
On the cases we're doing right now?
Uh-huh.
I believe they did. That's why I believe they did. That's why we're asking for a.
I mean, did he ever make it? I don't see anything where they came off of the bond.
Okay.
For Mr. Johnson, Bostic, can you see it?
Looking
Mr.
into
Johnson,
it.
wave your hand, Mr. Johnson.
You don't see anything, Bostic?
I'm looking into it.
All right, go ahead. What says the state?
Your Honor, the state believes that the bond is fair and reasonable as said. What we have listed on the last bond order is the $5,000 for the entering auto and a UJR PT1 for the last two, the criminal trespass and loitering or prowling. If that's the case, based on his criminal history, his open cases, he does appear to have a problem with entering autos, which leads to subsequent problems where people are finding guns and the like. But he did confess to the case dealing ending in 9123. He was seen on surveillance and all that. So we believe the bond in that case is fair and reasonable as set. As it relates to the other case that was mentioned by defense counsel ending in 9122, we don't oppose the bond recommendation that he made.
A bond surrender was done. That's why he needs a bond on those three. There's no bond on those last three charges.
All right, so y'all just come off of that. All right, Mr. Schaub, go ahead one more time because I was trying to look it up on 2-3. What did you ask for on one ending in 9123?
3,000 on each. That would be a total of 6,000.
Okay.
Okay, and then the CP.
No, that's a total of 9,000 on the one ending in 9123 because there's entering auto, criminal trespass, and loitering and prowling.
Okay.
I think that's the one that already has the bond.
Well, pre-trial came off of it, so. All right, here we go. All right, on position 1, no drugs unless prescribed, no alcohol, no weapons. Stay away from 520 Daniel Street in Atlanta, Georgia. No further contact with Christopher with a K, Brinker, Brinker. You're going to have an ankle monitor paid for by the county with a 24-hour curfew except for court, lawyer, medical. You can leave for employment as long as you supply proof of employment, the name of your employer, a schedule, and the exact location you'll be working. You have to supply that to the ankle monitoring company and to your lawyer. Mr. Schaub, where's he going to live?
I understand he's going to be living with his mother. Let me just make a clarification. You've given 3, 3, and 3. The what I'm looking at the bottom of this is 9122. That's a criminal trespass and theft by receiving felony, correct?
Yeah. Entering auto and criminal trespass.
Oh, okay. So that's just one count.
No, there's entering auto. Next count is criminal trespass.
Okay.
Where will he be living?
That's 3 on each.
Okay. Where's he going to be living?
He's going to be living with his mother.
Okay. All right. So the ankle monitor will be paid for by the county. Now that's going to be 3 on entering auto, 3 on criminal trespass. Position 2, 3 on entering auto, 3 on criminal trespass, and 3 on loitering and prowling. No drugs unless prescribed, no alcohol, no weapons. Stay away from 554 Orme, ORME Circle in Atlanta, Georgia. No further contact with Morgan Shelton, SHELTON. No further contact with your co-defendant Tyreek, TYREKE Daniel. Ankle monitor be paid for by the county, sir. So you can leave for court, lawyer, medical, work, as long as you supply the name of your employer, proof of employment schedule, and the exact location you'll be working. You have to give it to the income earning company and to your lawyer, who again turn it over to the state. Best of luck to you, sir. You can leave the booth. 3 North.
Thank you.
What is wrong with you, 3 North?
Pardon me?
I don't know. I don't know. All right. Thank you, Mr. Scheib. Have a good one.
Thank you, Judge. Have a nice evening. Bye.
All right. Let's see. Jack Wade, raise your hand.
Good evening, Judge.
Oh, Ms. Chavez didn't tell Mr. Perez he could leave.
I haven't seen the deputy come back in for Cobb yet to get them.
Oh, okay. So booth 3 and Cobb, there you go. Tell she, Deputy, you can get, we're done with Cobb. Thank you. All right, Jack Wade.
Rondon was following up for one of the inmates. She was following up to see if he was represented.
Mr. Anthony Cantu DeVille, what did you see, Miss Rondon?
It looks
Mr.
like
DeVille was in Cobb.
Okay. What is it?
he
look
does
like?
need,
He needs C3?
yes, and I can't see an update yet to see if anybody has actually been appointed, but I've reached out to my supervisor about that.
Okay, hey, Deputy, if you could tell Mr. Cantu DeVille, he's got to get a C3 attorney, and we'll get him back on the calendar as soon as he gets assigned another lawyer, okay? Thank you, Deputy. Stay healthy and safe out there. All right. 22 CP 209-628 21 Bostic Jack Wade, 233 days out, indictment, burglary, smash and grab, criminal damage to property, 2nd degree. There's a $32,000 good bond as of 10/3. Pre-trial.
Good evening, Judge.
In regards to Mr. Jack Wade, 9 prior arrests total, currently on first offender probation for aggravated assault, 18 SC 159-411, sentence 9/16/19, 1 year confinement, 4 years probation, prior possession of marijuana, criminal trespass, family violence, 2 arrests for probation violation, also misdemeanor terroristic threats and disorderly conduct. Nothing further.
All right. Go ahead, Ms. Rini.
Good evening, Judge. Judge, my client has been in, like you said, 213 days. The bond
233.
233. I'm sorry.
It's okay.
So he's been in 233 days. His father is active in his life, but he's a single dad, and he wants to be able to bring him home. I'm his attorney. I am retained on his case here. He also has another case. That's 21 CP 202521. There's a bond set on that one as well at $20,000. That's obviously not on your calendar, but the problem is obviously the finances. But I do want the court to know Pathlight Counseling, and we have been working with Britt Paramore. We are trying to, Mr. Paramore was unable to do, we want to do a mental health evaluation, was unable to do it last week. But we've been working with him because we want to get him into either an intensive outpatient or possibly even inpatient. He definitely he's got severe mental health issues, and in the jail for all this time. I don't know if he's getting his medication. I mean, it's not good. What I'm asking the court to consider is we do have these things in play that we're trying to work out and work with a counselor. I know that we're fine with and I know from the last bond, I think the bond was set at $32,000. The state. What I'm asking the court to consider is a $5,000 bond with all of the other conditions, because with the $20,000 bond on the other case, my client's father may be able to make that to get him home. But we do plan on, again, we've been consulting with Pathlight Counseling, and we would be getting him into there our goal is either an intensive outpatient program or possibly inpatient, but we need to get that started. It just hasn't been able to happen because Britt Paramore was unable to get down to the jail last week. But we are, we're trying to see what we're going to do. Again, these cases, nothing has been done with them. I don't know when they're going to resolve, but we want to take some action with this, even if the cases aren't going to be moving. We are trying to move in the right direction to get my client help.
All right. What says the state?
Your Honor, the state believes that the bond that is currently set is appropriate. Your Honor, as you heard from pretrial, He is currently on first offender. And then he picked up not one, but 2 cases, Your Honor, both being of the same nature. We believe that the defendant is at risk to reoffend, Your Honor. And Your Honor, we believe the bond is appropriately set.
All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with Soraya, Soraya, last name Khoury, and no further contact with Corazon, Corazon, Rojas, Rojas. Stay away from 11705 Jones Bridge Road. Can have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, mental health treatment. So is he going to be living at that Alpharetta address?
530 Creek Landing Lane, Alpharetta.
Uh-huh. Does he also need leave to go to apply for work?
Judge, I would ask that you put that in there if that, I mean, depending on how we're working with the treatment provider, that may be a possibility.
All right. You can also leave for work as long as you provide proof of employment, name of your employment, a schedule, and the exact location you'll be working. You have to supply that to the ankle monitoring company and to your lawyer who can supply it to the state. And we got here, what was said before is you must reside at the 530 Creek Landing Lane in Alpharetta, Georgia. So we'll do 15 and 3, 15,000 and 3,000. Best of luck to you, sir. You can leave the booth.
Can I just ask which prosecutor is handling this reach out to at this point? They be able to tell me that?
I guess right now it's in non-complex. They don't really know since it hadn't been indicted.
Okay, thank you.
If you need to email somebody, who does she need to email? Who's the point person? Ms. Dixon. I mean, before it was Mr. White, but he's out ill, so.
Your Honor, I would defer her to Mr. Malkin, who is now the supervisor over that unit.
Brad Malkin.
Thank you very much.
All right. Thank you.
That completes my business. May I be excused?
Yes, ma'am. Have a good weekend or a good week. All right. I got Cedric Cobb. Wave your hand, Mr. Cobb. Sir, you can leave the booth. Mr. Wade, you can leave the booth. All right, let's see. It's position 10 pretrial. It's Cedric Cobb, 22 CP 212265, 123 days without indictment. Unlawful for a person employed by, associated with a criminal street gang is to conduct or participate in criminal street gang activity. Possession of Schedule 3, 4, or 5 controlled substance with intent to distribute. Possession of a firearm or knife during the commission of or attempt to commit certain felonies, willful obstruction of law enforcement officers, and possession of drug-related objects. No bond as of September 24th. Wow.
2 prior arrests. Open case 21 CP 201990 marijuana with intent. 22 SC 184939 aggravated assault with a deadly weapon. Aggravated assault, family violence, false imprisonment, aggravated stalking, battery, family violence, theft by taking assigned to Judge Wall. Nothing further.
All right. This was 123 grams of marijuana, Mr. Cook. Go ahead.
Thank you, Your Honor. Can you hear me okay?
Yes, sir.
Great. Thank you. Mr. Cobb is 23 years old. He has no prior convictions. He's born and raised here in Atlanta. He's actually going to be living in DeKalb County with his fiance. She is has been on the call with us today, and she is he's going to be living with her, and I have an address for that. It's in Stone Mountain. He is a high school graduate of Mays High School. He's actually set to go to Valdosta State, where he had a scholarship, but unfortunately some significant family matters came up, and he became sort of the household in charge of the household, and that just took him out of his original plans. Unfortunately, he's gotten in trouble, just arrests for the last year. This matter, it's a domestic with a former girlfriend. That's the pending indicted case. It's nowhere near being resolved. It's just been indicted. And Your Honor, the matter here involves a gang charge, similar, kind of like what we heard earlier today, a simple traffic stop at a park where my client was accused of smoking marijuana sitting near a car, and he runs from the police after they start investigating it. No word of any gang activity until he's arrested several months later after he had tried to turn himself in. And all of a sudden there's a gang activity charge with no other relevant facts in any of the reports that we've seen that connect any of the activity at issue with criminal street gang activity. The good news is, Your Honor, is that he is moving out of the area and no longer resides in that area where he was a young man and may have been messing around with the wrong folks. So we welcome an ankle monitor and a curfew at his residence that I will provide in just a moment, allow him to go get a new job, but otherwise to stay out of Fulton County absent court. Your Honor, we are asking for a $7,500 bond total, no prior convictions. I think it's important. He does have a child on the way. That's what we asked for. Thank you, Judge.
All right, what says the state?
Your Honor, Mr. Cook's recitation of the facts are pretty close to it, except for the fact that Mr. Cobb is a documented member of the 127 Mafia, which is a subset of ABG. At this point in time, the officers did observe him in the park smoking marijuana. They initially stopped him and inquired about the marijuana. He had a small amount on him. At that point in time, they were just going to write him a citation. As they looked into the vehicle, they observed a bag. They asked all the individuals there's 3 individuals, who the bag belonged to. They got shoulder shrugs, and before they knew it, Mr. Cobb had taken off running. They detained the other 2 individuals and charged them with just possession of misdemeanor marijuana. The vehicle was Mr. Cobb. He had the keys and everything. Mr. Cobb eluded the police from May the 13th, 2022. So he was actually apprehended by the fugitive squad on September the 24th, 2022. So he didn't turn himself in. So he shows he's a flight risk. There was a gun found in the car. He has a violent history. Based on these facts, Your Honor, he is a threat to community, threat to commit more crimes. We'd ask the bond be set at $200,000, Your Honor.
All right. We got no drugs unless prescribed, no alcohol, no weapons. Stay out of Fulton County, sir, unless you're here for court or see your lawyer. Fill up a gas in DeKalb County. Come to Atlanta. Don't run out of gas. Don't get a flat tire. Go back home. All right. Going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, and medical. Stay away from 670 Martin Street Southeast, which should be okay because you're going to stay out of Fulton County. Also, no further contact with anyone associated with, affiliated with, living with, acting like 127 Mafia, Atlanta blood gangs. Let's see, YFN, Young Fly, N-word, ending in AS, ending in A, not an ER. Atlanta Blood Gang, Young Slime Life, and Sex, Money, Murder, and also no replicas of weapons. Stay away from 72 Georgia Avenue. No further contact for co-defendant Adrian, Adrian Mathis, Mathis. Let's see, 1 second. $50,000, $20,000, $10,000, $10,000, and $5,000. Best of luck to you, sir.
Thank
You
you.
can leave the booth. Thank you, Mr. Cook. Have a good evening. All right, I got Shabazz Clay. Wave your hand, Mr. Clay. Thank you.
And Judge, we are holding for his attorney, which is
he's
Mr.
not here
Partridge.
yet still. Okay. Judge Glamble is running long today. All right, what about Deontay Franklin? All right, that's position 7, Bostic 22 CP 213385. 95 days without indictment, no bond as of October the 20th. You got ag assault, armed robbery, possession of a knife or a firearm during the commission or attempt to commit certain felonies, and kidnapping. Free. Rah.
7 prior arrests total. Only felony appears to be a 2013 marijuana with the intent to distribute, 2 misdemeanor convictions, nothing further.
All right. That's Fair Claw.
Yes, Your Honor, that's
Okay. All right. And do you have an address where he'll be living?
Yes, I do.
And you can file the change of address. I just want to know if it's in
Okay,
Fulton County.
4712 Flat Shoals Road, Union City, Georgia, 30291.
Okay. All right. Go ahead with your argument.
Okay. Mr. Franklin is 30 years old. He has roots in the Atlanta community, born and raised on both sides, and has a good deal of family support. His mother and his aunt are joining us today. He was raised in the church. He does not present any risk of flight. He's always made his court appearances. He has no recent priors. I believe the last one was back in 2014, and it was nonviolent, and a couple of misdemeanors. He presently has a family. He lives with his fiance and her son. He's also the caretaker for his mother, who is he's here 3-4 times a week. She's receiving chemotherapy. Family. He's known by everyone for his kindness and generous and gentle behavior. He has a stable work history. He has not been working in the last 102 days because he has been in confinement, but he does have a history in the construction industry with grading work. Quickly viewing the narratives by the investigator and Minson and McCourt, and he does profess his innocence from the beginning, seems that maybe a misidentification, even with the facts, it does not really show kidnapping. He was in an apartment house with 11 apartments, and they may have just grabbed somebody. It doesn't show they could really identify who it was who, one, did not point a gun at anyone, and two, stole some items, which they said he told them where they were, which really makes no sense. We would ask that the court grants a total bond of $35,000. Right now, he does have a bond for 3 of his charges, and the 2 no bonds are the armed robbery and the kidnapping. We would ask that I don't know if he qualifies for pretrial. We would ask that the armed robbery be set at $10,000, as well as the kidnapping. Again, serious charges but scanty evidence, and he has no violent history. And that the total bond be $35,000, so that the other 2 bonds be reduced accordingly.
So he has no bond on anything.
Okay, well, I'm showing that he did have a bond of $15,000 on the ag assaults and the possession of firearm.
No, his bond was set on October 22nd. And it says no bond.
Okay, I'm looking, I don't see a date here, but this is from the booking sheet with municipal court. So.
All right. What says the state?
Your Honor, the state's position is that the bond is fair and reasonable as set in a no bond status. The facts as alleged in this case there's 2 victims in this case, Your Honor. The date of the incident was back in September. One of the victims stated that this defendant approached him, pointed a firearm at him, and took his cell phone and his keys. The other victim stated that a firearm was put into his back. One of the first victim attempted to stop the defendant. And that's kind of where the identification kind of happens. And the defendant says that, hey, somebody else did it, but it wasn't me. He never says who the somebody else was. Based on these facts, Your Honor, this is a pretty brazen incident. We do believe that the defendant is a danger to the victims in this case and to the community. We do believe, although he does not have a lengthy criminal history, that he is likely to reoffend based on these circumstances, Your Honor. So we do believe that the bond is fair and reasonable as set. However, if the court is so inclined to set a bond in this matter, we would ask that it's a high bond, at least $100,000, Your Honor.
You want to give me a breakdown?
Let's do for the aggravated assault. Let's do $25,000 for the first one, $25,000 for the second ag assault. The armed robbery, let's do a $25,000 for that one. Possession of a firearm during the commission of a felony. Let's do $5,000, and the kidnapping, let's do $20,000 for a total of $100,000.
No drugs unless prescribed, no alcohol, no weapons, no further contact with Corey Smith, Cory, last name Smith, no further contact with Fofana Mohammed, Fofana, last name Mohammed. Stay away from 47 lawyer, medical, and employment, as long as you supply name of your employer, location you'll be working, proof of employment, and a schedule. You have to turn that over to the ankle monitoring company and to your lawyer who can supply it to the state. Obviously, sir, if you have to go take care of your mother, you can leave for that, but you have to let them know when you're going to take care of your mother, unless you're going to live with her. 25, 25, 25, 5, and 20. 25, 25, 25, 5, and 20. Best of luck to you, sir. You can leave the booth. If that's it for you, thank you, Ms. Burkle.
Okay, thank you. Have a
Brian Jones. Brian Jones, wave your hand.
Judge, we're holding for his report for his attorney as well.
Oh,
I
Eric
am
Johnson.
on.
Oh, he's
I
on.
am on.
Okay, good. I thought I saw you. Okay. All right. So it's position 9, Bostic, 22 CP 213198. Brian Jones, 102 days without indictment. Aggravated assault, possession of a firearm or a knife during the commission of or attempt to commit certain felonies, possession of a firearm by a convicted felon, reckless conduct, discharge of a firearm near a public highway or street. Trial.
6 prior arrests, open case 22 CP 206660. Cruelty the first, battery, substantial visible harm. Also 22 SC 180551, firearm by a convicted felon, 5 counts. Prior aggravated assault in 05. Nothing further.
All right. Go ahead, Mr. Johnson.
Yes, Your Honor. Mr. Jones is a lifetime Atlanta resident. His history has been laid out by the state. We would indicate that this matter that took place was a dispute between Mr. Jones, an alleged dispute between Mr. Jones and another individual that he does not have any contact with. So we believe that Mr. Jones would be eligible for a reasonable bond in this case, whatever conditions that the court will be inclined to place. He does not have a relationship with the alleged victim in this case. He does not know where the alleged victim lives, so there's no chance of him intimidating any witnesses in this case. He has been a resident of Fulton County for quite some time, Your Honor, so we do not believe that there is a threat of him not showing up to court. As the state indicated, he does have a couple of open matters that are in Fulton County right now. He was given a bond on those matters, and he has not violated the conditions of the bond by failing to appear in court. As the charges are stated, Your Honor, we do not believe that he is a threat to frustrate the administrative justice in any way, and Mr. Jones is fully prepared to adhere to any conditions, including a curfew, ankle monitor, or anything else. He is self-employed with a disposal company, so he goes around and carries loads for individuals as well as seasonal work through labor companies when available, Your Honor. So he is gainfully employed. He's the primary caregiver for his family. His fiance is currently expecting. I do believe that she will be giving birth shortly. So Mr. Jones really needs to get out to take care of his family in this particular matter, Your Honor. As stated, he has no contact with the victim in this particular matter, and no way to influence the victim or intimidate the victim in this case. And so we would ask that he be given a reasonable bond in this matter, not to exceed $50,000 to secure his appearance in court. Thank you, Your Honor.
Thank you, Mr. Johnson. Where's he going to live? Is he going to be in Fulton County?
Yes, Your Honor.
Okay.
I can give he lives. I can give you his address in 1 second, Your Honor.
If you just put it on, do the change of address in the clerk's office. I'm just checking to see if he's going to live in Fulton. What says the state?
Your Honor, we believe that this defendant should remain in a no bond status. The facts as alleged in this case, the victim in this case, Mr. Willard Hood, is the repo man. He was given a task to come out and repo the defendant's vehicle. He saw the vehicle, connected the vehicle, and started to drive off with the vehicle, at which point the defendant came outside with his firearm, pointed the firearm towards the repo man, and then switched it to the air, and then fired a round into the air. and told the victim in this case to drop his vehicle. Based on that, Your Honor, in the criminal history that we heard, we do know that he does have some outstanding cases that are open and pending. We also heard that he is a convicted felon and he was in the possession of a firearm at that time. Also, there's an open case, as we heard, in Eden for possession of a firearm by a convicted felon. What primarily concerns the state is that this defendant is violent, and although he may come back to court, we do believe that he is a danger not only to this victim, but to the community at large, because he continues to possess a firearm, although he should not and is legally not supposed to have a firearm. And he discharges the firearm as he did in this case. As such, we do believe that this defendant is violent, will continue to be violent, will continue to pick up additional felonies, and he should remain in a no bond status.
If I may respond, Your Honor.
But he's been in 102 days, Ms. Valentine, so statutorily he has to have a bond.
Yes, Your Honor. So if a bond is set in this matter, Your Honor, we would ask that the bond is high, at least $200,000.
Do you want to give me a breakdown?
For the aggravated assault, $100,000. For the possession of a firearm during the commission of a crime or a felony, $25,000. For possession of a firearm by a convicted felon, $50,000. Reckless conduct, $5,000, and reckless conduct, 15, and discharge of a firearm near public highway or street, 10. I think that gives us 200,000. If I can.
All right, go ahead, Mr. Johnson, quickly.
Yes, Your Honor. I'd just like to point out that the repo man in this particular question came in and took the car out of my client's garage. It was not on the street. And so the street that they're talking about with regards to the discharging of the firearm was right in front of my client's house. It is not like he was out in a crowded place or anything else like that. The repo man unjustifiably entered my client's garage and began to take the car out of the garage without permission or without notifying Mr. Jones that he was a repo man. So Mr. Jones came out and responded to him. The individual did not identify himself as a repo man, and in fact, was not willing to give Mr. Jones any information with regards to this matter. And as stated before, the gun was fired in the air. It was never pointed at the victim in this case, nor was the gun shot in the direction of the victim. So we do believe that any assertion that my client is a threat to the victim is unfounded by the facts in this case. And Your Honor, the fact that the state would attempt to give him a $50,000 bond just for possession of a firearm and $15,000 for misdemeanor reckless conduct is ridiculous. As you stated before, my client has been in jail for 107 days. The state has had 102 days, Your Honor. The state has had ample time to indict this matter. So therefore, exercising a $200,000 bond in this matter where no one has been harmed whatsoever, there is no injury to anyone in this particular case, is highly unreasonable.
All right, gotcha. No drugs unless prescribed, no alcohol, no weapons, no further contact with Willard Eugene Wood. Stay away. Okay, so is he living at the McMurray Drive?
Yes, Your Honor.
Okay. Have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, work. You have to provide proof of employment, name of employee if you work for yourself, your schedule you're going to be working, the exact location you're going to be working, sir. If you don't provide that on a weekly basis to the ankle monitoring company, to your lawyer to provide it to the state, you'll be violating your bond condition. Yeah, Mr. Johnson. Also, with all due respect to you too, Mr. Jones, when a bullet goes up in the air, it's got to come down somewhere. So you're just lucky it didn't hit somebody. If you don't have a target you're aiming at, don't just willy-nilly go shooting it off in the air. I might sound pretty stupid like cornbread milk with my accent, but I'm smart enough to know a bullet's got to land somewhere. Wasn't a bright move, right? So here I'm going to do 40,000, 15,000, 15,000, 10,000, and 5,000. 40, 15, 15, 10, and 5. Best of luck to you, sir. Ankle monitor be paid for by the county. Thank you, Mr. Johnson. You can leave unless you have something else. All right, Ms. Rondon. We got DeAndre Brown. Wave your hand. DeAndre Brown. No DeAndre Brown yet? All right, what about, let's see, Freddy's Benitez Sosa. You don't need an interpreter, do you, sir?
He does not.
All right. We got a 2-1, it's 22, Bostic, 2-1, CP 203-311. Freddy's Benitez Souza, 164 days without indictment, possession of controlled substance 2 with intent to distribute, possession of drug-related objects. Looks like it was released through pretrial services and they came off of that bond. Pretrial.
Open case 22 CP 213982, interference with government property. 22 SC 1848858, aggravated assault, battery, family violence, assigned to Judge Barwick. Nothing further.
All right. Go ahead, Ms. Perez. Oh, Ms.
This
Rose.
will be my case, Judge. Thank you. Mr. Benitez Sosa is 26 years old. He has resided in Georgia for the past 10 plus years. I did speak with his mom today and he can return to her address, and I have filed a change of address. That's going to be in Gwinnett County. It's a Norcross address, and he'll reside there with his siblings and his mother. He made it to the 9th grade, and Judge, he has been on SSDI for MH issue since 2012. That's been the basis of a lot of these cases. He has told me he's back on his medications. He's doing a lot better. I believe the initial bond on this case was to wrap services, and Judge, that medication just wasn't working for him, but he is doing much better now. Your Honor, he does have a $25,000 bond in his indicted case and a $2,500 bond in his other unindicted case. And Your Honor, he's not even able to make or come close to making either of those bonds at this time, nor is his family. We would ask the court to consider reinstating the pretrial bond, or in the alternative, a very low bond. As the court knows, he's been in custody now 164 days, not necessarily on this case, but he is in a no bond status on it. And Judge, just given the facts of this case, the fact that it's a drug case, we think that that's a reasonable request. Thank you.
All right. What says the state?
Yeah. He set at 34,500. Your Honor, you've heard from pretrial, in which they've come off the bond, and I can only believe that they came off the bond because Mr. Benitez Sosa picked up 2 additional charges. Your Honor, he also picked up a charge while in the jail. That interference to government property is a jail incident. Your Honor, so we would just ask for the bond to be set at 34,500 because we understand that he has been in custody for some time.
All right. No drugs unless prescribed, no alcohol, no weapons. Stay away from 881 Roswell Creek Lane. Stay out of Fulton County, sir, unless you're here for court or to see your lawyer. Fill up a gas in Gwinnett, go to court, go see your lawyer, and leave. Don't run out of gas. Don't get a flat tire. Don't stop at Chick-fil-A. Don't get lunch. Just go straight to court and leave. He's got the other ones. I'll do $4,000 on count 1 and $250 on possession of drug-related objects. $4,000 and $250. Best of luck to you, sir. You can leave the booth.
Thank you, Judge.
Ms. Rosenhuber.
Yes, Your Honor, and that concludes my business, if I may be excused.
Absolutely.
Thank
Oh,
you, Judge.
sorry, dropped my pen. All right, let's see. Quinn Charles Neely. We have the lawyer here for Mr. Neely. Hold on, we'll check on yours. But we got Mr. Partridge here. So Shabazz Clay. All right, position 6, pretrial 22 CP 212583 VGCSA schedule 1 or 2 with intent to distribute, possession of cocaine with intent to distribute, possession of firearm by a convicted felon during the commission of a crime, possession of firearm or a knife during the commission of certain felonies, possession of drug-related objects, driving, fleeing, attempting to elude, reckless driving, and signals required. Pretrial.
In regards to Clay, 7 prior arrests. Open case 19 SC 166649, possession of firearm by a convicted felon, battery, capital offense, 3 counts, aggravated assault with a deadly weapon, firearm during assigned to Judge Leffridge. 2017 conviction, firearm by a convicted felon. 2017 possession of cocaine. Nothing further.
Mr. Partridge, you know where he's going to be living?
Yes, Judge, it'll be in Fulton County. Good evening,
Okay.
by the way.
All right, go ahead.
Yes, Judge. Mr. Clay has been in custody, Judge, for over 100 days at this point, Your Honor. Judge, this is his first time before the court after first appearance where we're asking the court, rather, to consider a bond of $42,000. And I can provide a breakdown if the court requires such. But nonetheless, Judge, we're asking for that bond in consideration of the time that he spent in custody. Moreover, Your Honor, Mr. Clay's case that is pending before Judge Leffridge, I do also represent him in that case as well. He has appeared for every court date for that particular case. There's been no issue with regard to FTA at all there. The charges also have been reduced. He's now charged, as it relates to that case, with a misdemeanor battery, as well as that of a possession of a firearm. So the aggravated assault and the charges that it started out as have now been reduced. So that is not the case there. With regard to this case, Your Honor, we did have a preliminary hearing a couple of weeks ago. Not to go too far into the facts, but I believe this is a case where my client was profiled. He was at a gas station in his vehicle, or in a vehicle rather that belonged to someone else, but that he was driving. But in essence, Your Honor, it's my understanding that he was then approached by the officers unprovoked, and my client left the scene. After that, Your Honor, he was later found after chase was given by police, and when he was found, local or nearby where he was found is a bag that the officers are alleging belonged to my client. There was no actual identification by the officers to say that the bag belonged to my client. In that bag, Judge, were the gun as well as the contraband, the drugs that were found that my client is being charged with, which is the reason why we're asking for a bond that is $42,000. That would be, I guess, considered a low bond in this situation, considered my client's history, Judge. I believe that we have strong evidentiary motions that we will argue when the time comes, when this case does move forward. I understand that that is not the arena now, but we are asking that Mr. Clay does have the opportunity to make bond since he's been in custody for over 100 days. If the court does see fit to impose an ankle monitor, there would be no objection from that of Mr. Clay, Your Honor, but we are asking the court for a reasonable bond. Thank you.
All right, what says the state?
Your Honor, this defendant does have a lengthy criminal history. The no bond order that was entered in September did list out that he's likely to reoffend. He's a danger to the community and likely to fail to appear. The state does believe that those things still hold true and there has not been a significant change. The facts that the defense counsel recited are pretty accurate. However, the officers that were there were, looking for someone dealing narcotics. They were on the dark side of the gas station, which, no one would be there. There's no pumps, so there's no real good reason to be there. When the defendant did flee the scene, when he fled the scene at that time, Your Honor, he was driving very fast. He forced several drivers out of their lane, which is very dangerous. So considering his criminal history and the facts as alleged in this case, Your Honor, the state would request that the bond be set at $100,000 with the breakdown of $15,000 for count 1, $15,000 for count 2, $15,000 for count 3, $15,000 for count 4, and $10,000 for the 4 subsequent counts, Your Honor, for a total of $100,000.
No drugs unless prescribed, no alcohol, no weapons. Stay away from 3260 Donnelly Hollowell Parkway. Have an ankle monitor paid for by the Orca Project. You can leave for court, lawyer, medical, or employment. Provide proof of employment, name of your employer, schedule, and exact location you'll be working, sir. I'll give you guys supply that to your lawyer and to the ankle monitoring company, and your lawyer can provide that to the state. Count 1, 15, count 2, 15, count 3, 10, count 4, 10, count 5, $250, count 6, 5,000, count 7, 3,000, and count 8, 250. 15, 15, 10, 10, 250, 5, 3, and 250. Thank you, Mr. Partridge.
Thank you, Your Honor.
Sir, you can leave the booth.
Judge, I'm slow at math. I just wanted to get a quick understanding of the total bond so that I may get that over to my client's family. I apologize.
Can you write these numbers down?
30, 15, 15, so 30, 40, 50,
250.
250, 5.
You got 15, 15, 10, 10,
15.
250, 5, 3, and 250.
Okay, got it. Thank you, Your Honor. I'll get it over to them now.
Have a good evening. I'll tell Judge Glenn not to keep you so late next time.
Thank you, Your Honor. I appreciate your flexibility.
All
Have a
right,
great
have a
one.
good one.
Thank you.
All right, we got DeAndre Brown. No DeAndre Brown yet. What about, okay, Quinn Charles Neely. So we have the attorney for Quinn Charles Neely.
Judge, I've reached out and sent that attorney an email, and I have not heard back as of yet.
All right, John Leah. All right, Ms. Rondon. At position 19, Bostic 22 CP 209708, John Leah, 231 days without indictment, aggravated assault with a deadly weapon, possession of a firearm or knife during the commission of a felony, theft by taking, misdemeanor. As of June the 8th, there is no bond.
Extensive arrest history, at least 50 prior arrests, 21 North Carolina, 29 in Georgia. A few felony convictions, couple for burglary, theft by shoplifting, at least 6 misdemeanors, one being a battery, family violence in 2017, one arrest for FTA in 2018, at least 5 arrests for probation violation, 1 arrest for parole violation, nothing further.
All right, go ahead, Ms. Rondon, and do you know where he'll live?
Yes, Mr. Lee is 49 years old. He has been in the Atlanta area since 2005. We do have an address, and that would be 37 Lyndhurst here in Atlanta. He'd be living with his friend Pamela Watson. He does have 2 children. They are ages 5 and 26. Mr. Leah completed the 11th grade in North Carolina and works as an artist. He sells paintings and murals for the past several years. And prior to that, he was working as more than 90 days. And so he is entitled to bond, and we would ask bond to be set as follows: $10,000 for the aggravated assault charge, $5,000 for the possession of a firearm charge, and $1,000 for the theft by taking.
All right. What says the state?
Your Honor, the state believes that a more appropriate bond would be $100,000, Your Honor. Going into the facts of this case, Your Honor, the defendant stabbed the victim, Mr. Bailey, several times with a box cutter. Is alleged in the warrant, Your Honor, that the defendant and the victim knew each other. So we do have some concerns about the victim's safety, Your Honor. The victim did sustain injuries in which he was hospitalized, Your Honor. We do also have a concern that Mr. Leah is a risk to flee, as you heard, Your Honor, from pretrial, that he does have an FTA out of DeKalb County from 2018. So we believe, as well as the criminal history outside of Georgia and North Carolina, Your Honor. So, Your Honor, we believe that the bond should be set at $100,000.
All right, no drugs unless prescribed, no alcohol, no weapons. Stay away from 3102 Martin Luther King Jr. Drive. No further contact with Marvin Bailey. Have an ankle monitor paid for by the Orca Project with a 24-hour curfew, except for court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment, schedule, and the exact location you'll be working. You need to supply that to the ankle monitoring company and to your lawyer so they can supply it to the state. I'll need 50,000 on count 1, 20,000 count 2, and 3,000 on count 3. 50, 20, and 3. Best of luck to you, sir. You can leave the booth. All right, is the attorney for about Patrick Kemp? Patrick Kemp.
Yes, Your Honor. I am here, Sarah Eslami, representing Mr. Kemp, as well as Miss Alicia Clinton as well.
Let's see. Patrick Kemp, if you're there, wave your hand. All right. There's 2 cases, Bostic. So we got 25 and 26. 22 CP 211567. Patrick Kemp, 160 days out of indictment. Got theft by receiving stolen property, possession of firearm during the commission of or attempt to commit certain felonies. As of August 18th, there is a $30,000 good bond. 26 is 22 CP 212245. Patrick Kemp, 160 days out of indictment. There's no bond as of September the 19th for aggravated assault.
In regards to Kemp, multi-state offender, 1 in Missouri, 7 in Kansas, 11 in Georgia. Felony convictions, burglary, Kansas, theft of property, and a burglary. Prior simple battery, open case in Clayton for aggravated assault, 2 counts, and fleeing and eluding. Nothing further.
All right, go ahead.
Your Honor, my client and I are at the mercy of your honorable court to grant a reasonable bond. The charges that pretrial read, if I'm not mistaken, the Kansas charges are very old. And respectfully, Your Honor, it's laughable that my client was charged in the first place, as not a single element of aggravated assault has been met. There's nothing in the incident report that should ever bring an indictment. Second, he's been incarcerated for over 140 days without a preliminary hearing where bond may be addressed. Any other higher amount would tantamount to no bond due to the facts that neither my client nor his family have the financial means to afford a higher bond, as well as the fact that he will likely not be indicted. I'm a conflict defender, Your Honor. I was not privately retained. Mr. Kemp, the defendant, does have significant ties to the Atlanta metro area, and he poses no flight risk as he has never failed to appear. After the preliminary hearing was not scheduled as required, my client's constitutional rights were violated as there was no probable cause or justifiable reason to continue to incarcerate him. I did file a motion requesting the preliminary hearing back in November. No proper notice was given at the disciplinary hearing. If I may present, Your Honor, with a brief case summary, my client was standing at the top floor of your jail, outside of his jail cell, in the jail pod where this incident occurred down below. There were other defendants in this case who were also falsely charged from watching this incident from the top floor, overlooking the bottom floor where the incident occurred inside of cell 208. The accused defendants were only charged based on the aggressor, Marcus Freeman's arbitrary choosing. Mr. Freeman is a known addict and bully who steals other inmates' store, which is exactly what he was doing during this incident. Your Honor, as you know, pursuant to OCGA Code Section 16-521, aggravated assault can only exist when a person assaults with the intent to murder, rape, or rob. In this case, my client's only intention was for the actual aggressor and alleged victim to stop fighting. No intent or actions were taken that could ever suggest an assault. Neither did any deadly weapon exist, nor was any bodily injury caused. There was no object, device, or instrument that would result in strangulation, and no firearm was discharged. Prior to his incarceration, my client worked at Kroger Distribution Warehouse. My client has a passion for cutting hair, and he hopes to open his own barbershop one day. My client is not a danger to the community, as he has no convictions of any crimes of violence. He does not pose a threat to the community, as this is a bogus charge. My client is not a flight. After being released, he will reside in the Atlanta metro area in Clayton County at 225 Johnson Road, 2E, Forest Park, Georgia, 30297, with his girlfriend and their children. His professional ties are all in the Atlanta metro area, as well as his mother's residence. He will only be able to afford bond through a bonding company, which will further secure his appearance in court. During my time with my client, it's become apparent that he suffers from an untreated mental health condition. It is cruel to keep someone with a mental health condition incarcerated without bond for a crime that was never committed. Your Honor, my client was not involved in the way that this charge indicated him in the incident that took place in your jail on September the 16th, 2022. He simply witnessed a fight from a completely different floor of the jail. A proper investigation into this incident was never conducted, so any inmate in the vicinity was therefore falsely charged and accused of having involvement. Your Honor, we respectfully request that you grant bond for my client in this case in the amount of $8,000. Thank you, Your Honor.
What says the state?
Your Honor, the state has a different recitation or presentation of Mr. Kemp's criminal history. We do show that Mr. Kemp does have a 2017 fugitive from justice charge. He has 2019 FTA out of Clayton County. And you heard from pretrial, Your Honor, that he does have a pending case that involves fleeing and eluding, Your Honor. We do believe the defendant is a flight risk and will not return to court. You also heard from pretrial that he is a multi-state offender, Your Honor. While defense counsel is correct that he does not have any serious violent convictions, Your Honor, what is most concerning to the state is that he does have a 2021 aggravated assault charge out of Clayton County that is pending, Your Honor. And going into the facts of the case, the victim, Mr. Freeman, did, as defense counsel indicated, point or name Mr. Kim as one of the participators. This was a jumping, Your Honor, in which the victim had several puncture wounds to his back. He did have some injuries resulting in the possible puncturing of his lung, Your Honor. So, based on those facts, Your Honor, we believe that an appropriate bond would be in the amount of $60,000.
All right. So on position 25, ending in 1567, no drugs unless prescribed, no alcohol, no weapons, no further contact with Juan Rodriguez. Stay out of Fulton County, sir. This year for court, see your lawyer. Fill up with gas over there in Clayton County. Come to Fulton County, go to court, see your lawyer, leave. Don't stop for gas anywhere. Don't stop for lunch. Don't get a flat tire. If you have to go anywhere north of the county, get on use 285. Stay away from 7100 Old National Highway. You're going to have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, work, as long as you supply the name of your employer, proof of employment, location, and your schedule. Supply it to your lawyer, and she will supply it to the state. And also need to let the ankle monitoring company know. 10,000 on count 1, 10,000 on count 2. On position 26. No drugs unless prescribed, no alcohol, no weapons, no further contact with Marcus Freeman. Stay out of Fulton County, less sheriff or court, or see your lawyer. Same thing, sir. Don't run out of gas. Don't get a flat tire. Don't stop for Chick-fil-A. Don't stop Taco Bell. Don't stop anywhere for lunch. Do it in Clayton County. All right. No further contact with your co-defendants. Quentin Owens, Chaz Banks, Willie Stinson, Cordaz Harrison, Cordaz Harrison, Jermaine Watts, Antoine Denson, Alfred Dodd, Jerome Mitchell, Ian Smith, Donovan Castellanos. You have that 24-hour curfew except for court, lawyer, medical, same as to employment. Name of your employer, proof of employment, location, and the schedule to the ankle monitoring company and to your lawyer who can supply it to the state. $20,000 good bond. Best of luck.
That concludes my business for the day. May I be excused?
Yes, ma'am. Have a good evening.
Thank you, Your Honor. You as well.
Your Honor, Attorney Aslami did everything. I didn't have to say a word. May I be excused?
Oh, she stole your thunder.
She did. She did a wonderful job. I'm conflict counsel as well.
Yes, ma'am.
Thank you, Judge.
Thank you. Y'all have a good evening. Quinn Charles Neely. Okay.
Good evening, Your Honor.
There you go. He's here now. All right. So we got, there's two cases. It's 12 and 13, Bostic. 22 CP 212381 Quinn Charles Neely, 131 days without indictment, possession of a knife or a firearm during the commission or attempt to commit certain felonies, possession of MDMA with intent to distribute, possession of cocaine with intent to distribute, possession of a controlled substance in Schedule 1 or 2 with intent to distribute, VGSA Schedule 3, 4, 5 controlled substance, VGCSA possession of controlled substance Schedule 1, 2 with intent to distribute, possession of marijuana with intent to distribute, possession of a firearm or a knife during the commission of or attempt to commit certain felonies, possession of a firearm or a knife during the commission of or attempt to commit certain felonies. It was 14 oxycodone, 8 tramadol, 82, it says blue M, 81 MDMA, and 359 grams of weed. On position 13, it is 22 CP 212382, selling, possessing, distributing other associated with ecstasy, possession of marijuana with intent to distribute, and possession of firearm during the commission of a felony. There is a $25,000 good bond on there as of September the 16th. And on the first case, there is already a $75,000 bond as of September 17th. Pre-trial.
In regards to Mr. Neely, 7 prior arrests, 1 arrest for probation violation, 1 misdemeanor, prior conviction for cocaine and carrying a concealed weapon, open case in Clayton County, improper attorney. About 3 other misdemeanor for driving offenses, a DUI, and 3 counts of VGCSA. Nothing further.
All right, go ahead, Mr. Ronson.
Yes, Your Honor. Mr. Neely doesn't have felony convictions. The Clayton County case is pending. We are adamantly denying those allegations along with these. There's already been a bond set in these matters. Just the bond is too high. We're looking for a bond reduction. We're looking for $25,000 on each for $50,000. Mr. Neely is a lifelong resident of Metro Atlanta. He's a Clayton County resident. He is not going to, he has no failure failures to appear. He will be at every hearing with me. Is desperately trying to get him bonded out, but can't quite come up with the funds to get to that $100,000 mark. We would ask that you reduce the bond to 25 and 25 for a total of 50.
All right, what says the state?
Your Honor, we believe the bond is fair and reasonable as said. The defendant did get first offender treatment in Fulton County for possession of cocaine back in 2008. He does seem to keep running into the law, having different issues. Based on the facts here, Your Honor, one case was an undercover controlled purchase of illegal narcotics and a firearm, which resulted in the search warrant that was executed in the other case. So we do believe the bond that's currently set is fair and reasonable. There has not been a substantial or any change in circumstances outside of the fact that they don't have the means to pay, which is not good reason to reduce the bond.
Mr. Ronson, is he going to live in Fulton County?
I believe he's either going to be living in Fulton or Clayton County, Your Honor. And if I may address, the bond's supposed to be fair and reasonable, not overall, but to the individual. They can't come up with the money. That's unfair and unreasonable.
Sir, are you going to be living in Clayton County? Give me a thumbs up or a thumbs down. All right, good. You can stay out of Fulton County unless you're here for court or to see your lawyer. Don't get gas in Fulton County. Don't eat lunch in Fulton County. Don't get a flat tire in Fulton County. No drugs, no alcohol, no weapons. You have an ankle monitor paid for by the Orchid Project. You can leave for court, lawyer, medical, and employment as long as you supply the name of your employer, proof of employment, schedule, and the exact location you'll be working. You have to provide that to the ankle monitoring company and to your lawyer so it can be provided to the state. Stay away from 895 Mercury Drive. So we got 10,000 on count 1, 4,000 on count 2, 4,000 on count 3, 4,000 on count 4, 4,000 on count 5, 4,000 on count 6, 4,000 on count 7. You got that, Counselor? 10, 4, 4, 4, 4, 4, 4, 10, and 10. And on position 13, 22 CP 212382, no drugs unless prescribed, no alcohol, no weapons. At ankle monitors, same thing, going to be provided by the county, the Orchid Project, with court, lawyer, medical, and employer, as long as you supply the name of your employment, proof of employment, schedule, and the exact location you'll be working, supplied to the ankle monitoring company and to your lawyer. You can supply it to the state. Stay out of Fulton County unless you're here for court or to see your lawyer. Same thing I said before. Don't stop for gas. Don't stop for lunch. Don't get a flat tire. Take 285, go where you want to go, but do not run out of gas in Fulton County. 4,000 count 1, 4,000 count 2, 10,000 count 3. Best of luck to you, sir. You can leave the booth. Thank you, Mr. Ronson.
Thank you, Your Honor. That completes my business. May I be excused?
Yes, sir.
Thank you, Judge.
State. Is Ms. Rondon still here? So are you also handling Zarius Shields? Zarius Shields?
That'll be handled by Ms. Javonna Smith.
Okay. Zarius Shields, Mr. Shields, wave your hand. All right. All right. Here we go. That's position 24, Bostic. Zarius, I'm probably pronouncing it wrong. Shields, 22 CP 209650. No disrespect, sir. Criminal attempt to commit armed robbery. You've been in 332 days without indictment. There's a $25,000 good bond as of June the 6th. Excuse me, June the 7th. Pre-trial.
No prior adult arrest.
All right. Go ahead, Ms. Smith.
Your Honor, Zarius Shields, he just recently turned 18. He is from Atlanta. The highest grade that he completed was 10th grade at North Metro High School in Atlanta. He did, before the incident, he was attending Atlanta Tech College where he was pursuing his GED. He does live with his mother and his brother at 2591 Ether Ridge Drive, Northwest, apartment D419, Atlanta, Georgia, 30318. Your Honor, I've been in communication with Zarius's mother, Ms. Tanika Shields, and she is the primary parent and also the sole financial supporter of Zarius. So with the current bond that's set at $25,000, it's impossible for Ms. Shields to afford. And given that Zarius, he doesn't have an adult criminal record, he's also not a flight risk. He's been in holding since July of 2022. We are requesting that Zarius, that he receives UJR to pretrial services. And with Ms. Shields, we are requesting that as a condition that Zarius enrolls into a GED program. And then in alternative, Your Honor, if you don't see fit to grant the UJR to pretrial services, we are requesting a reasonable bond not to exceed $5,000 so that Ms. Shields can receive help from the bail project.
So is he going to be living the same place with his co-defendant, Kentario Shields?
Yes, that is his brother. However, I think he is being held somewhere. I'm not sure what his status is currently.
All right. What says the state?
Your Honor, the state believes that the bond is fair and reasonable as set, Your Honor. Although Mr. Shields does not have any adult criminal history, he does have a 2019 robbery out of juvenile. And now, Your Honor, just what, three years later, we're back with a criminal attempt to commit robbery. Your Honor, going back into the facts of this case, the victim indicated that two males approached him and they were attempting to carjack him. They snatched his keys and attempted to start the vehicle, but it wouldn't start without an actual key fob. And then the males, meaning Mr. Shields and his co-defendant, then began to attack the victim in this case by hitting him with closed fists and choking him. And the officers indicated that the victim was left with some injuries, bruises to the face and neck. So, Your Honor, we believe that given the nature of this offense, that the bond is reasonably set, Your Honor.
All right. No drugs unless prescribed, no alcohol, no weapons, no further contact with Anthony O'Brien, O'Bryant. Stay away from 3800 East Main Street in College Park. Stay away from all MARTA stations, sir. This happened near a MARTA station. You're probably expelled from MARTA and you're banned from riding it anyway. You can have an ankle monitor paid for by the county with a 24-hour curfew, court, lawyer, medical, and employment as long as you supply the name of your employer, proof of employment schedule, and the exact location you'll be working. You have to supply that to the ankle monitoring company and to your lawyer, who can then supply it to the state. I want you have no further contact with your co-defendant, Kentario, Kentario Shields, Shields, and you must enroll and complete a GED program. $20,000 good bond. Best of luck to you, sir. You can leave the booth. And I'll also email the DA's office and remind them about some of these that have been in over 300 days or the high 200 days to see if they can't find out when they're going to get them indicted. All right, DeAndre Brown. Thank you, sir. All right, Ms. Rondon. 22CP211711, DeAndre Brown. And we'll hear the other motions of people that aren't in jail as soon as I finish this one. 154 days without indictment, no bond as of August the 24th, possession of cocaine with intent to distribute, possession of firearm by a convicted felon, theft by receiving stolen property, felony, expired license on persons, and giving false information to law enforcement officer. Pre-trial.
In regards to Mr. Brown, extensive criminal history, 4 arrests in Florida, 25 in Georgia, Florida, conviction for fraud, cash, 5 arrests for probation violation, open case. Forgot some numbers. 22 SC 182, something. Schedule 1 or 2 with the intent to distribute 2 counts, marijuana with the intent to distribute, MDMA with the intent to distribute, Judge Lethbridge, conviction, carrying a pistol without a license, simple battery, disorderly conduct, controlled substance, cocaine with the intent, aggravated assault, CWAC, misdemeanor, simple battery, family violence in 2022, couple of misdemeanors, 3 FTAs, and has a hold in Jonesboro. Nothing further.
All right. Go ahead, Ms. Rondon.
Before you is Mr. Brown. He is 36 years old and he is born and raised in Atlanta. He has his whole family here in the area, mom, aunts, uncles, grandparents, nieces, nephews, siblings. He has completed his GED. He also has 2 children, a son and a daughter. He does have an address in Jonesboro that he will be living at. That is 681 Flint River Road, apartment 54A. Prior to his incarceration, he was working doing environmental construction, and it's my understanding that he'll be able to get this job back. For the court's concerns about the FTAs mentioned by pretrial, we would consent to an ankle monitor. We would also be fine with a curfew as long as there were exceptions for work, medical, and lawyer. He has been in for over 90 days, and so he is legally entitled to a bond, and we would be asking the court to set bond not to exceed $15,000.
All right, what says the state?
Your Honor, we heard the defendant's lengthy criminal history, also that he is a multi-state offender with arrest in Florida. Based on that, Your Honor, the state does understand that he is entitled to a bond. However, we do have some the fact that he is a convicted felon and he continues to possess a firearm. As such, we would ask that the court set a bond at least $100,000 on in total on this case.
So we had 7 rocks of crack cocaine, approximately 2 grams. No drugs unless prescribed, no alcohol, no weapons, no further contact with Yvette, Y-V-E-T-T-E Griffin. No further contact with your co-defendant, Dereka, D-E-R-E-K, Askew, A-S-K-E-W. Have an ankle monitor paid for by the county with a 24-hour curfew. You can leave for court, lawyer, medical, and employment as long as you supply the name of your employer, proof of employment, and the exact location you'll be working and a schedule. Supply that to the ankle monitoring company and the state. Let's see. I'm going to go 10,000, 15,000, 15,000, 500, and 500. 10,000, 15,000, 15,000, 500, 500. Best of luck to you, sir. You can leave the booth. Thank you, Ms. Rhonda.
Thank you. And Judge, that does conclude my business for the night. May I be excused?
Absolutely. Have a good evening. Good to see you.
You as well. Great.
All right. We got some motion. Yes.
Well,
Yes, ma'am.
sorry, that's the only one for me. So may I be excused?
Absolutely. Yes, ma'am. Thank you both.
Thank you. Have a good evening.
All right. You too. All right, Mr. App. So we got London Bolar. London Bolar, I got to start your camera for me. London Bolar, you got to start your camera for me.
Sorry, Your Honor.
I'm sorry. Can you hear me? I'm sorry.
Yeah, but you need to start your camera.
I am. I'm trying to figure out how to do that now.
I won't mute you because I don't need to hear you say anything. All right, this is a motion for bond modification. So it's one pretrial on this calendar. It is 21CP199536 London Bolar, trafficking in heroin, unlawful for a person employed by or associated with a criminal street gang to participate in criminal street gang activity and reckless conduct. There is a $310,000 bond which she has made. Pretrial.
She was released to a hold, and now she has an open case: conspiracy, tampering, street gangs, 2 counts. And that was to DeKalb. Nothing further.
All right, go ahead, Mr. App.
Your Honor, the DeKalb case and the Fulton case are essentially the same case, but the case spread over 2 different counties, so that's why there was a second charge. I've been in regular communication with the DeKalb prosecutor. That case is indicted. The Fulton case remains unindicted, and purposefully so. I spoke with Kara Convery about a year ago. I don't think she's any longer with the DA's office, but
yeah, she's at the
time intention of ever indicting the Fulton case. Essentially, DeKalb has taken the lead. My client is the girlfriend of the ringleader in a 10 or 12 co-defendant case. That's mostly her crime because she was basically arrested in order to try and flip her boyfriend, who's the main defendant and the father of her child. The My client has no criminal history, Judge. She has lots of ties to Atlanta. She owns a home she lives in. She's had no violations of her bond conditions. She's not a flight risk. She's lived her whole life in Metro Atlanta. She's a single mom. She's a homeowner. And she's been in complete compliance for 2 years on a case that's never going to get indicted. She posted a $300,000 bond, Your Honor. She's not at risk. She doesn't want to lose the possibility of violating that bond. And she's proven that over the last 2 years. And Your Honor, she wants to, we're asking the court to modify the bond by just removing the ankle monitor and lifting the curfew. That's all we're asking for. And the reason is she wants to attend family events, social events. She wants to take her 2-year-old child to music classes in the playground and other places where, it's very difficult to socialize if you're wearing an ankle monitor. I know that may seem trite to the court, but she's having a difficult time, getting her kid to get into socialized environments because she's got to wear the ankle monitor. In addition, Your Honor, she's an active member of her church, but she can't do any community service programs like work at the Atlanta Food Bank or volunteer with the church in organized programs because she has the ankle monitor on and has the curfew. So she's essentially, I don't want to overplay my hand, but she's more of a witness in the case than she is a defendant, Your Honor. She was, her involvement in this co-defendant drug trafficking case is the most minor of roles. As I indicated, in speaking with the district attorney in the Fulton case, at least, they had never had any intention and don't have any intention of indicting the case. So I would just ask the court to remove those 2 conditions, allow her to remain on bond and the other conditions, and humbly, respectfully ask the court to allow that to occur.
And she's had how long has she had the ankle monitor on? Because I don't see it on the May 20th.
It's 2 years. Well, I think it's May of 2020. I think she got arrested in February of. Okay, I see. It's
May of 21.
It's a year and a half she's had the ankle monitor with 0 problems. She's entirely in compliance.
All right. What says the state?
Yeah, I'm going to leave this in your discretion. There's no change of circumstances, so I'll let you make a decision on this one.
Even when I spoke with Judge McBurney, a year is kind of a long time if it hasn't been indicted to keep her on an ankle monitor. So we'll remove the ankle monitor, but I'm still going to give her some sort of curfew. So how about 10 p.m. to 7 a.m. Is that good?
That's fine.
Ma'am,
she's not trying to go out. She's a single mom. She's not trying to go out and party or break the law. She wants to go have dinner with her aunt and, live a normal life.
That work for you, ma'am? Okay. All right. And so you can go ahead and remove that ankle monitor.
Thank
you. Sign it.
Remove the ankle monitor, a curfew of 10 p.m. to 7 a.m.
7 a.m. Yes, sir.
Got it. Thank you, Your Honor.
All right. Thank you. Thank you, Ms. Bowler. All right. So I got Ms. Rosenhoover. You still here?
Judge, it's going to be Mr. Bailey for that case.
Oh, okay. All right. So it's Jaime Gray, 22 CP 212. Of a felony, and it's a $5,000 good bond. Pre-trial.
Good evening.
Go ahead, Bostic.
Jaime Gray is out on a pretrial bond, no prior arrest.
All right. What would you like to modify, Mr. Bailey?
Good evening, Your Honor. We are here requesting a modification and a modification with the bond in regards to removing the ankle monitor and also relaxing the curfew. Your Honor, Mr. Henry Gray is 17 years old. He's in 12th grade. He is joined here by his mother, Anna Gray. He lives with his mother at 2631 Chadwick Drive, Decatur, Georgia, 30034. also his father is on this link, Your Honor. He is at MLK, Martin Luther King High School. He played football. He has average to good grades. He is scheduled to graduate on time. He's never been in any trouble. In the facts of this case shows that he was several people in his vehicle, Your Honor, including 2 adults. I think there were some things found that nobody claimed, and that is the gist of why he was charged. I do believe that he is innocent of these, what he was alleged. He's never had a prior arrest or anything of that nature. Your Honor, we're asking that, and Your Honor, in regards to his school, he did make honor roll this semester. We're asking that he is removed from the ankle monitor altogether. The 2 adults that were arrested, they don't have ankle monitors at all. He does again live with his mother. They have hired me for the case itself. And as far as the curfew, Your Honor, we do believe that there should be a general curfew, and the general curfew should be set by, his mom. His mom will, of course, enforce that. It's just that the nature of the curfew that they have now, it affects the entire family. It affects the entire family as far as them going out, having family functions. He has to be at home at a certain time. That makes the entire family have to go home. And of course, the entire family wasn't involved, even in the car, even though we believe that he's innocent of these charges that were alleged. So we're asking that there is a general curfew, but it's relaxed. That one that is, of course, imposed and monitored by his mother, but that would include him with the ability to go out to family functions and enjoy his high school senior year without any imposing conditions as far as staying out late that involves just in the entire family. We're asking at this time, Your Honor, that the ankle monitor is removed. He hasn't been in any trouble. He does live with his mom. His mom is here. She can testify that she will make sure that he comes to court. He's 17 years old. He's not a flight risk. And again, the facts will show that he was just in the car. That basis, Your Honor, we ask that it's modified without the ankle monitor, and the curfew is adjusted so that the mother is in control of a general curfew, and that there are reasonable conditions that will allow him to be around his family if they're on vacation, if they're on a church outing, without them having to go home at 10 o'clock.
All right, what does he need to do after 10 o'clock? What good happens after 10 o'clock?
Well, Your Honor, he can't.
I mean, what kind of family functions are going on past 10 o'clock?
Well, if they're out on vacation, Your Honor, if they're out on vacation, then they have to be at home.
Well, Mr. Bailey, if you do something where they're going to go on a vacation, I mean, I'll be glad and send it to the state. I'd be glad to give him, a time to go on vacation. You'll have to supply, the schedule, when he's going, when he's returning, and where he's going to be staying there. He's going to have to supply all that. I mean, when's he going on a vacation? But I'm not going to remove the ankle. It's just been on since September. We could reset this out another pretrial. You'll come off. You'll stop the monitoring. What do y'all see on now? 6 months. Boston.
Yeah, sure.
It's normally 120 days without indictment.
Okay.
So
I mean,
that's just 4 months, and he's been on how long?
Since September.
So the 4 months is actually almost up.
Yeah. So if you want to come back another 60 days, we can talk about, but I don't see a whole bunch other than, like I said, I can amend it and say if they're going out of town, he can supply the, you got any problem with that, Ms. Dixon, or?
None whatsoever, Your Honor. State would like for there to be a curfew.
Yeah, well, I'm going to keep the same curfew though. I mean, it's 7 a.m. I bet you he don't roll out of bed at 7 a.m. when he's out of school. So we'll leave that. But if he wants to go, if their family's going to go on a vacation, or they need some special thing they're going to go on, a family reunion on a weekend, and let's say it's in, I don't know, Florida or Tennessee or, just somewhere else in Georgia, that as long as you supply an order or you supply the details in an order, I'll be glad to sign it and copy the state on it. And, but put that in the order that if an order supplies the name, the time, location, the schedule, he's leaving here, he'll come back there, then, I'll be glad to sign that anytime he needs to go out of town or attend something. But it's good his mom's sticking with him, getting him out of trouble, because, you kind of get wrapped up in who you hang around. So kind of got him in trouble.
I understand, Your Honor. And respectively, I think the court mentioned something about coming back in a few months to see if we can get the ankle monitor removed.
Uh-huh. Sure. Just file another motion and we'll get you on here.
Okay, thank you.
See how he's doing. But yeah, if you want to submit an order, say that when he's traveled, that I will allow it, as long as it's reasonable. He's not going to go away for 6 months, weekend or a week, that's fine. I'll be glad to sign that as long as you copy the state on there each time. But he just needs to keep doing good. And thank you, Mr. Bailey. If you just email that to me or to Orca, they'll send it to me.
Thank you, Your Honor.
Have a good evening. All right, Montavious Hawkins. Who's handling that? Mr. Wright. So this is 21CP202124. This is he's got a $68,000 bond he's out on for armed robbery, possession of a knife or a firearm during the commission of a felony, possession of a firearm by a convicted felon. Pre-trial.
I don't have anything on a Montavious Hawkins.
Number 3, you didn't have a criminal history?
Mine is Ricky. My number 3 is Ricky Hamilton.
Well, no, that's 4. But anyway, you didn't have a Montavious Hawkins? I sent you
No,
the
my number 4 is Alexander Koku.
That's why I sent you the calendar. Let's see what it said on August the 11th. What does it say? Old. His last arrest was 2019 for failure to appear for driving while license suspended. He does have an open case, 20 SC 175251 in Fulton, on probation for fleeing, attempting to elude possession of cocaine with intent to distribute, possession of marijuana with intent to distribute, striking an unattended vehicle too fast for conditions, effective or no tail lights. 17 SC 150170, since 7 years, 1 to serve community, serve balance, 6 years on probation in Fulton County. All right. Go ahead, Mr. Wright.
Your Honor, I filed this motion for modification based on the fact that I think it may have been, Your Honor, but I think he was granted bond back in January 24th of 2022. It has almost been a full year that he has been released on that bond. He actually made bond 2 days later. Since making that bond, there are no new arrests. He had 2 pending matters. One was a misdemeanor case in Fulton County. He resolved that case, so it was disposed of. He has another felony case, which is out there in Paulding County. I'll stand in my place. I have a negotiated plea. As soon as the court, convenes, we'll be tendering that negotiated plea. That's going to be a probation plea, so there's no custodial component to it. In other words, there aren't any negative things that have changed that he's caused, but for literally a year, and has asked if he can at least, he understands having to remain on bond, but can he get that ankle monitor off, since he has been showing the courts both here in Fulton as well as his one other pending case in Paulding County, will continue to do so, but is simply asking if he can be relieved of the ankle monitor stipulation.
All right, what says the state? It's been a year.
Your Honor, the state is opposed. Your Honor, this is a serious violent offense. Mr. Hawkins is a state C recidivist, Your Honor. I do have his criminal history. GCIC was run. From our office, Your Honor, it appears that he has 2003 armed robbery conviction, 2003 kidnapping and armed robbery conviction, Both of these are out of Fulton County, Your Honor. He has another 2018 robbery that was indicted. He does have several FTAs, one out of Fulton County, which is the state's main concern is that he does have FTAs, a recent one being 2019, another one out of Spalding County 2019, and then one from DeKalb County in 2016. Your Honor, we believe that there has been no change in circumstances and the ankle monitor should be remained.
Well, he was in jail for 168 days without indictment when I set the bond January the 24th, 2022. So I'm gonna add stay out of Fulton County unless he's here for quarter to see his lawyer, but he can have the ankle monitor removed February the 1st.
Thank you, Judge.
All right. If you just want to send me that, but he's got to stay out of Fulton County unless he's here for quarter to see his lawyer. He can stay out there in Dallas, okay?
To prepare and send it to you?
Yes, sir. Y'all have to prepare it and send them. You can send it to the Orca email address and they'll send it to me. Orca at Fulton County GA. Thank you. Have a good evening.
Thank you, Judge.
All right. All right, Mr. Jerome, Ricky Hamilton, 22 CP 210253, theft by taking.
Yes, Your Honor. So Mr. Hamilton is currently on, I believe, on a curfew, and he's just trying to get that amended because at the moment he's completed everything that they've asked for him for the bond, but he's a regional manager and he needs to travel for work, and because he can't travel, it's limiting his income, and for that reason we're asking to amend basically pretrial for him.
All right, pretrial. What says you? Pretrial.
Per his pretrial person, he can actually be removed from pretrial services. I think he's been on there about a year. And per our standards, and actually would have been taken off pretrial. It's supposed to be 120 days.
Let's see. So he's removed. I'm just trying to pull up the bond, Mr. Jerome. Hold on one second.
All right.
Yeah, and Judge, all those calendars you sent me are for tomorrow. I didn't get this calendar.
Oh, I forwarded you the email from Mr. Boyd that had them.
I didn't get that. The 4 calendars are for tomorrow.
So
we got 4 add-ons.
The curfew
for
was
tomorrow?
through. Hey, so the curfew was through pretrial, Mr. Jerome?
Yes, it was through pretrial.
Okay, so yeah, because all I see on here on his actual bond, since he's being released from pretrial from their supervision, is just stay away from 699 Spring Street. So if you want to do something that, yeah, his curfew is lifted.
Okay. And
can
he be removed from pretrial entirely?
That's what Bosick just said, that pretrial was releasing him because it'd been over 120 days.
Okay. All right.
And so you want to just send me the order just to make sure, even though he's released from there, make sure it doesn't get all jacked up somewhere in between.
All right, and I'll email that now. Can you remind me, who do I need to email that to?
Orca at FultonCountyGA.gov.
Okay.
All right. Thank you very much. Thank you, Mr. Hamilton. Have a good evening. All right. I got Alexander Akoku, Mr. West. Where's West?
Judge, I'm going to reset that one because I don't see where Mr. West is on.
All right. So did we get everything, or did that should be everybody, right?
All right, LT, am I done? I mean, Judge, am I done?
Yeah, I just got promoted. Yes, sir. Yes, sir. You're done. All right. I guess that's it, everybody, right?
Tomorrow. Come on,
Gloria. So there's 4 add-on calendars tomorrow?
Yes, there are. You should have received them because it says you were in the evening court list. And the one for today, it was only 1 calendar sent with the add-on. So when you received the original calendar, the add-on was attached to that.
Yeah, my add-on only had those 4 people. I didn't have 5 positions. I only had the 4.
I'm not sure because everyone else has had 5, so I'm not sure where yours.
Okay.
And Ms. Robinson, this is 88 Dixon. I know you said that position 5 on the add-on was being reset. Do we have a reset date?
I'm going to reset it for February 13th.
Thank you.
All right. So, and Bostic, you be ready tomorrow because I got